So the biggest problem that our firm encounters year in, year out for the more than 25 years that I've been practicing is failure to notify an insurance company. Late notice is what we call it. And late notice is, if you think about it, it's a simple concept. You bought insurance, you bought it to protect yourself. Something comes up that is going to be a potential claim, or a lawsuit is filed against your company, and your company or you don't give it to the insurance company for them to get involved and take care of it. The failure to do that is almost as if you wasted money on your insurance policy, because unless you tell the insurance company that you have a claim or a potential claim, they're not going to be able to investigate it. They're not going to be able to determine whether it's payable. They're not going to be able to hire a lawyer on your behalf. And so it's just a very common mistake. And sometimes it happens, but it is a problem that I have seen in my practice, and I've been practicing now 32 years. I've seen this problem in my practice the entire 32 years, and it never seems to change. So a couple things I want to share about this problem is that you have different types of policies. If you're a business, if you're an individual. If you're an individual, maybe you have life insurance. Maybe you have long-term disability insurance. Maybe you have long-term care insurance. You also have homeowners insurance, perhaps, maybe auto insurance. You have health insurance. There's all these types of insurances that people as individuals have, and then businesses, in addition, have potentially all types of other insurance. They have policies that protect them from general liability situations that arise. They have directors and officers insurance. They have employment practices liability insurance. They have cyber insurance. They have errors and omissions insurance. And all of these policies will have specific language requiring the insured to notify the insurance company when there is a potential risk that could be covered by the policy. And getting around that problem can often be insurmountable depending on the factual circumstances that surrounded the failure to give notice to the insurance company or the state law that applies. So I caution all of the insureds out there that they need to be mindful of the need to notify the insurance companies for the policies that they have purchased, so that they don't run into that particular problem when they're seeking coverage from their insurance companies. And what I want to add is every insurance policy and every year, the language in the policy about when and how long you have to give notice to the insurance company can be different, right? And so my firm has lots of different insurance policies, and anytime I determine that there may be a risk that's potentially covered by insurance, I go back to the policy and I determine whether it's something that I need to put the insurance company on notice about. Now, obviously, if you get sued and somebody hands you a lawsuit, that's an obvious situation where you need to immediately give it to your insurance company and don't wait. But there are lots of other situations and lots of other language and policies where they talk about notice of a claim, which is not a lawsuit, notice of a potential claim, notice of circumstances which might reasonably bring rise to a claim. And all of those depends on the facts and circumstances surrounding the situation. So I urge all of the insureds out there to remember that they don't want to get caught not having notified their insurance company and lose the opportunity to have sometimes a massive amount of coverage for a circumstance that they bought insurance to protect themselves for, and then wind up not being able to obtain it because they didn't tell the insurance company when the claim or lawsuit came in. So I kind of spent a lot of time on the first question, sort of explaining the late notice problems. So I want to focus more on the answer of what can insureds do to avoid late notice problems. And I've got three pretty good suggestions here, okay? One is task people in your organization to risk management. People that are responsible, and preferably more than one. So if you're the owner of the company, maybe it's you and one other person who's responsible for making sure that when things arise that could lead to the possibility that the insurance coverage may be accessed, that you know about it so that you can determine whether to put the insurance company on notice. So tasking people to risk management. And that will include, as far as I'm concerned, point 2, which is the people that are tasked to risk management should know what policies the business has, what types of policies they have, and for what periods they cover. And there should be some kind of a list that is accessible and available to the people, especially tasked to risk management. So when something arises that could potentially be a risk that's covered by insurance, they can refer to this little crib sheet that tells you, hey, we have these 5 different types of policies, and here's the coverage periods, and here's what kind of policies they are. And at the very least, even if that's not enough information to tell the person tasked with risk management what to do, it may be enough information for them to then go to step 3, reach out to the broker and inform them. Tell your insurance broker, hey, this came up. Could this be a claim? Do we need to tell anybody about this? And that is a great final step. When you're not sure sometimes, well, ask someone whose job it is, who you hired to go get you insurance, and whose job it is to provide notice if you ask them to do so, right? So if you're not sure and it's a little confusing, you go to your broker and you say, hey, this thing came in the mail. It's a letter. It's asking for X, Y, and Z. They're complaining. Do we need to put somebody on an insurance company on notice about this or don't we? But if you don't have people within the organization who are tasked to watch out and make sure that when things come in to the office or come into the business, that they may give rise to the possibility that you need to tell your insurance company, then things are going to fall through the cracks. Now, sometimes they fall through the cracks anyway, but if you set up your business to say, hey, I want these 1, 2, 3 people tasked to have risk management as part of their responsibilities so that they are aware when something comes in the door that could give rise to insurance coverage, they know that something needs to be done with it and they do it. That will minimize the likelihood that it falls through the cracks. One of the really important aspects of liability insurance is the insurance company's duty to defend. What is the duty to defend? So the duty to defend is either one of 2 things. It is either the duty of the insurance company when a claim is made or a lawsuit is filed to hire a lawyer to protect the interests of you, the insured, whether that's you individually or your business. Secondly, it may be that you hire your own lawyer and they now need to reimburse you for those costs, depending on how your policy is structured. But most people, for most liability policies, you have 2 things in a liability policy: the duty to defend, the duty for the insurance company to go get you a lawyer to protect you or your business, and the duty to indemnify, to pay any judgment or verdict or settlement up to the amount of insurance that you purchased to protect you from this risk, right? So simplest example, right, is you have a general liability insurance policy for your business with a $1 million limit. Somebody sues you because they were in your office visiting, they fell and they hit their head. They bring a lawsuit against the business, you give it to the insurance company, they have a duty to go hire a lawyer to defend that lawsuit and to pay any settlement that arises out of that lawsuit up to the limits of the policy, the $1 million. But for today's purposes, it's that duty to defend that is very, very important. The duty for them to go get you a lawyer and to pay the cost of that lawyer and to interact with that lawyer to determine whether or not it's a risk that's going to require them to indemnify you for some dollar amount up to the policy limits. And so when you're talking about the duty to defend, one of the reasons that it comes up so often in my practice, and one of the reasons why it's so important, is across the United States, the law views the insurance company's duty to defend as a really important, significant right of the insured. And the way the law is structured is they want the insurance companies to provide that defense, even if the insurance companies ultimately could get out of paying at all. The idea is, hey, if you get sued, even if there's a question about whether there's coverage, we want to make sure you're being defended by a law firm while we figure out whether or not there's coverage. And so there are these rules, and the general rules are, if you get sued and you take the lawsuit, you give it to the insurance company, they look at the lawsuit and nothing else, basically, in the most basic sense. And they compare it to the policy. And they say, wait a minute, is there anything in this complaint that is potentially covered by this policy? Even if it turns out to be false, even if it turns out to be fraud, even if they're lying through their teeth, even if it turns out later that those things don't wind up being the things that get covered, but there are uncovered things in the lawsuit that were clearly not covered, like, for example, punitive damages or quite often intentional acts. If there is a possibility that one thing in that complaint could be covered by the policy, boom, the insurance company has to hire a lawyer to defend you. And so what we say in the law and what the courts all say is, the duty to defend is broader than the duty to indemnify, because we want to make sure you all get yourselves a lawyer to protect you. So that is the basics of duty to defend. It's that your insurance company is going to get you a lawyer to defend you, and they have to do it if anything in that lawsuit is potentially covered under the policy. Whether or not it turns out to be covered later, doesn't matter. They need to defend you. Absolutely. And for today's purposes, I'm going to give you something that's going on right now in New York. It's a simple but important change in the law that got changed in most states. It's called the Child Victims Act. And it was an act that was passed by the New York State Legislature to extend the statute of limitations to allow people who are victims of sex abuse to file lawsuits against the people that abuse them or the people responsible for abusing them. And that has triggered, because that statute of limitations was extended until about the end of August of last year, lots of lawsuits got filed by people who claimed they were abused. Quite often it was churches, scouting groups, schools, all types of institutions where children were, where they then claimed they were victims of sexual abuse and brought lawsuits against the individuals and the entities where those individuals were employed. Again, schools, churches, scouts, all kinds of places that had adults supervising children where alleged sexual abuse occurred. So we're handling quite a number of these cases on the coverage side. And what happens is some of these lawsuits come in the abuse is alleged to have happened in the 1950s, in the 1960s, in the 1970s, in the 1980s, years and years and years and years ago. And the lawsuit comes in, so let's say it comes into a school district, and it's alleging sexual abuse by some teacher to some victim who hasn't been in the school for 40 years or longer. And so records are scarce, nobody really knows what went on. And what does the school district do with this complaint? Well, if they're smart, they give it to their insurance company. What does the insurance company do? Well, the insurance company quite often will refuse to cover it initially. And what they will say is, you didn't give us timely notice of the lawsuit, number one. And number two, the acts that were committed by the perpetrator of the sexual abuse were intentional acts that are excluded under the policy, and we're not covering it. And so in the meantime, every time I get one of these cases, I find out two things. Number one, and I'm not every time, but most every time, I hate to speak in superlatives, but I get the lawsuits and the client comes to me and they say, this was never reported to us back in 1983. We didn't know about it. We didn't know there was alleged sexual abuse. And that's because the children who were victimized didn't tell anyone. It didn't get reported to the school. There wasn't an investigation. And so there's actually an argument that, hey, we're notifying you now, insurance company, now because this is the first time we ever heard about it. And then the second thing is, and this is where the real duty to defend analysis gets interesting, is, hey, you're saying this is intentional conduct by the perpetrator and therefore it's not covered. Well, guess what? The lawsuit, when you look at the allegations in the complaint, claims that we, the employer, if it's a school district as an example, were negligent. We were negligent in hiring this perpetrator, this pedophile. We were negligent in supervising this person. We were negligent in keeping them on as employees. All those are claims of negligence, not intentional acts. So, number one, we didn't know about it. Number two, maybe the pedophile, the perpetrator, committed intentional acts, but the lawsuit against us is negligence, not intentional acts. You have to cover it. So what does that mean? I go into court, I file a lawsuit, and the first thing I do once the insurance company answers the lawsuit is I make a motion in the court to force the insurance company to defend my client. Why? Well, you say that notice is late, but you don't have any evidence that it's late, and we have evidence that it's not late. At the very least, that's going to be a question of fact that will have to be decided later. Okay? And number two, the complaint pleads negligence against my client, the employer, even if the perpetrator of the sexual abuse committed an intentional act. I've got counts in this lawsuit that, if I compare to the policy, are potentially covered. Negligent hiring, negligent supervision, negligent retention. So I have a basis, just on looking at the lawsuit and comparing it to the policy, I've got coverage. Give me a defense. And so that's how most of these cases turn out when I litigate them in that way, is I wind up getting the defense, because they can't prove there's no coverage at the very start of the case. They sent some letter that said there's no coverage, but when they get into court and they're dealing with this very broad standard of the duty to defend, and it's just based on the allegations in the complaint and the policy, they get stuck. Well, if we're successful in getting the insurance company to defend the lawsuit and requiring them to defend it, ultimately what will happen over the course of time is the insurance company will be defending our lawsuit for coverage, being forced to defend the victim's lawsuit that was brought against the employer and the pedophile, or the alleged perpetrator of the sexual abuse. So now they're spending money defending two lawsuits, and insurance companies are in business to take premium and pay claims. So they have a requirement that when a lawsuit comes in that may or may not require them to pay out indemnity and defense costs, they have to set a reserve and set aside money to make it available to settle this case and to pay these claims. And so because they're in the business of paying claims and they have to set aside money to do it, they ultimately wind up, over 95% of the time, in my experience, they wind up settling the case directly with the plaintiff, and my client's only expense was bringing the lawsuit against the insurance company for coverage and paying me to go do that. So getting that defense is usually a huge step towards ultimately getting the indemnity. So unless there's some really bad facts and ugly facts surrounding the case where they're going to really want to fight and their exposure is huge, my experience through all these years is if you force them to defend, whether you get the court to order them to do it, or quite often in these cases, I will make the motion and they'll just concede it. But either way, if they're defending the case, more likely than not, they're going to settle the case. And my clients, the insured, the business, the individual, will be out of it entirely. So that's another reason why that duty to defend and getting that duty to defend is so important, because it's not just a half step towards getting your coverage. It's a 3/4 or more step towards getting your coverage. And another reason why it gets coverage is because 99.9% of cases settle anyway, right? So in order for an insurance company to ultimately determine whether or not something's covered, as an example, if there's 5 claims in a lawsuit, 3 aren't covered, 2 are covered, potentially. Until the case is over, the lawsuit for the injuries by the victim, we don't know what the jury or the judge is going to find. Are they going to find that a bunch of intentional acts were committed that aren't covered? Are they going to find negligence? Are they going to find something else? where then a final coverage determination on the duty to indemnify can be determined, well, no one's ever going to know because they're going to settle. And when they settle, nobody admits to liability for anything. Nobody admits they committed intentional acts. Nobody admits they committed negligent acts. So because the insurance company knows you're not likely to ever get an outcome in the underlying injury suit, whether that's property damage, whether it's physical injury, whatever it is, whether it's economic harm, they don't know what the outcome's going to be. It's better off just to settle and not go through all the risk of defending your client all the way to the end and finding out how that comes out. And so they're in for all these different sets of legal fees. They reserve the case. The plaintiff wants money and they want to get it from the insurance company. Boom, case goes away. And so strategically, that is why the duty to defend is so important.